Okay, we're ready to rumble. Here we go. Good afternoon to you all, and a very warm welcome to the Sinclairslaw seminar on special educational needs law in light of the recent Coronavirus Act. My name is Michael Charles, and as many of you may be aware from Facebook, I have dedicated my professional life to representing people and young children in order to secure the help that they deserve and a quality education. I've been doing this wonderful job now for over 25 years. I'm absolutely delighted that many have joined to watch this presentation via Zoom this afternoon, but I guess that some of you have nothing better to do. I suppose if the internet goes down, well, we'll be talking to ourselves, but hopefully not. So we're all relying on our good internet connection here. I must admit, at the very start, I've never done a seminar via this remote method before. So if we make a few mistakes, please forgive us. It's because of our technical wizardry is not always as good as our legal knowledge. And believe you me, the legal knowledge of our panel today is outstanding. But before I introduce you to the panel, I thought I would explain a few points regarding the seminar today. First, we aim to be about an hour to an hour and a half, and I've already myself received a large number of questions which I will try and put to the panel to answer. But if I miss some of those questions, please do drop us an email later at education@sinclairslaw.co.uk. During the seminar, we'll be unable to operate the chat facility, but we welcome you to use the question and answers button to put forward any questions which a panel member may be able to answer as we go along. Now, let me introduce you to our panel. Chris Barnett, he's a senior associate solicitor operating from our Twickenham office in West London. He was formerly the head of a specialist education and disability law department for over 7 years. He regularly acts for parents in special needs admissions and exclusion cases, and recently made headline news in a case in which he successfully opposed an appeal made by an independent school in which it claimed that it was not bound by a tribunal's decision to overturn an unlawful exclusion of a special needs child. He will provide today an overview of the Act. Welcome, Chris.
Thank you, Mike.
We have also with us Rachel Rees-Gralton, who has been practicing law for over 14 years and is the head of our Court of Protection team based here in Wales. She represents, to an exceptional standard, most of the most vulnerable people in the country. Welcome, Rachel. Hopefully she can hear us. Rachel, are you there?
Yes, I am. Welcome, everyone.
We have Robin Jacobs, our in-house barrister. He was formerly a member of a leading education team at Hardwick Building in central London. He has vast experience in dealing with all aspects of education law, from disability discrimination to higher education, and operates from our Twickenham and central London offices. Good afternoon, Robin.
Good afternoon, Mike.
Chris Mcfarland is a senior associate at our Cardiff office. He has always had a particular interest in special needs law, having grown up alongside his sister, who has autism and severe learning difficulties. This experience gives him a very unique perspective. He spent part of his career working within the Welsh Government, and since joining our team, his outstanding work has led him to secure success in the High Court against the adjudicator for higher education. He's also the head of our legal aid department based in Cardiff in Wales. Chris, a very warm welcome to you this afternoon. Chris, you're not there. Chris, are you there?
I'm terribly sorry. I think my connection went out, but good afternoon, Mike, and good afternoon, everyone else. Thank you for that warm introduction.
Sharoy Zak, he's our newest recruit. He joined the team as a solicitor within our West London office in March this year. He was ranked as a key lawyer in the prestigious Legal 500 directory and has demonstrated total commitment to ensuring that every child and young adult is provided with the education that they deserve. He works as my assistant lawyer and has already worked on admissions and special needs cases with us. Sharoy, a warm welcome to you this afternoon too.
Thank you very much, Mike, and good afternoon to everyone who's tuned in.
I'm also especially pleased to have Charlotte Hadfield, our guest and a dear friend. Charlotte is the head of education law at 3 paper buildings, a barrister's chambers in central London. Her main specialism is in public law, particularly education, health and social care. She has worked with me also in cases of professional discipline within the medical sector. The directories speak of her as the go-to barrister. So Charlotte, good afternoon to you.
Hi, Mike. Hello, everyone.
Well, we better get on with the seminar. I mean, it's going to be broken down into parts. Chris Barnett will begin this afternoon's seminar by beginning to provide an overview of the Act, whilst Robin will speak a bit about some of the concerns regarding Schedule 17 of the Act and the reasonable endeavours duty. Chris Mcfarland, Sharoy and Rachel will deal with an overview of different guidance documents issued by the government in both England and Wales. And this will include the guidance for vulnerable children, isolation within residential school sector and safeguarding. Charlotte will look at some of the practical problems that may be caused by the recently introduced health protection coronavirus restriction regulations, which we all know about because we're all locked away in our homes at the moment. And although the seminar will cover the law in England and Wales, many of the practical issues that will be raised may also be relevant in Scotland and Northern Ireland too. So I wanted to talk a little bit before we make a start and introduce Chris about the recent announcement of the permanent closure of a very well-known and highly regarded school in the west of England. A number of parents have contacted me via social media to explain that Shapwick School in Somerset has announced it will close at the end of this term. And so the peoples that will obviously hold a statement of special educational needs and an education and healthcare plan. And the school is designated to support children with specific learning difficulties, dyslexia and dyscalculia that includes, and of course dyspraxia. The quest to secure an independent school is often very, very hard and very long. And when you find a school that works so well for your child, the idea really that an abrupt end will be caused to the placement is plainly devastating. What can you do? Well, I would say that perhaps the most important thing to do first is to check the wording of your statement and education healthcare plan. Is it written in such a way that describes that a comparable school will be essential moving forward? If you have any concerns about the wording, we have a dedicated team here at Sinclairslaw who can help you with this. You may, of course, send the documents through to us for checking if you would like, and for that, you may send it to education@sinclairslaw.co.uk and a team member will be in touch. If the wording is good, the next obvious step is to look for another school that will be both suitable and available. In Somerset, there are quite a few schools that you may wish to look at, and of course there may be other schools further afield. Schools such as Mark College are very good, Breedon is a good school in Gloucestershire area, and perhaps maybe a thought is Appleton in Wiltshire. That school is, for example, a weekly boarding and a full boarding specialist dyslexia school. The local authority must engage with you, and it's always a good idea to invoke the dispute resolution provisions within the Education Act of 1996 if you're in Wales, and of course the Children and Families Act 2014 if you're in England. This will, if the dispute cannot be resolved informally, allow you to require the local authority to appoint an independent mediator to assist in bringing about a satisfactory settlement. The local authority, as we will soon explore through our panel today, is still going to be under an obligation to comply with the terms of the statement or the education and healthcare plan, and a failure to do so within a reasonable time may indeed be something that can be challenged via the courts in a process that some may know is called judicial review. Legal aid may be available for this, as legal aid is often assessed in the name of the child, subject of course to there being no other reasonable sources of funding that may be otherwise available, and of course financial eligibility. It's about time I now make a way for our first panel member, Chris Barnett, to take us through the Coronavirus Act of 2020. Chris, over to you this afternoon.
Thank you very much, Mike. So what I'm going to do is just provide a very general overview of the Act. Obviously, a lot of the decisions that are going to be made under the Act are yet to be made, and are covered in part by the guidance that my colleagues are going to be talking about in some more detail. But the framework for that, the impetus for this webinar, was the passing of the Coronavirus Act 2020 last week, having gone through Parliament in double quick time. And the focus that I want to quickly run through are the powers that it gives. it's important to say that the Act does not at the outset make any immediate changes to the legislation or to the framework for education law, or do so directly. And what it does is to create a series of powers and legal authorities for the Secretary of State for Education in England and for the Welsh ministers in Wales to give notices to give effect to particular changes to the education system. And those notices are will be, when they are made, the core of the changes to the law that need to be looked at. And they fall into three very broad categories of notice that could be given. The first category of notice that can be given is in relation to the closure of a school. The government had obviously already announced the closure of schools in effect prior to the Coronavirus Act being passed, and that was done under pre-existing legislation for dealing with public health emergencies. So the new powers in the Coronavirus Act are largely to give a bit more detail to what was previously available in that regard, but haven't needed to be used. The schools have obviously been closed in any event prior to the Act passing. The second category of notice that can be given is what the Act refers to as a continuity direction. And that covers a wide range of things, but the aim is to allow the Secretary of State to direct education providers, whether it be schools, childcare providers, colleges, or even universities, to provide education for children and young people who may otherwise not be able to access their normal school or any normal education. And the directions power that's given is a very wide one as a result. So it allows the Secretary of State to direct schools to reopen if they're closed, to stay open if they're not yet closed, to admit particular pupils, whether or not they were already on roll at the school prior to the Act being passed, to provide transport and to provide education in any particular way, which could be on site or through any remote form of provision that exists. So those are very wide powers that have been given, but obviously will almost certainly need to be implemented on a local basis based on local needs. And one of the additional things that the Act does is allow the Secretary of State to delegate those powers to local authorities. And in practice, it may well be that a lot of local authorities will be given that power to make local decisions about which schools and providers should stay open or make particular provision for young people and children in their area. The third type of notice that can be given, which is undoubtedly the one which causes the most concern and which most people will probably have heard about, is the power to disapply or to modify existing legislation and to change the obligations on schools and particularly local authorities in relation to the provision of education for children and young people generally, and particularly for those with special educational needs. And what the Act allows is for the Secretary of State to give certain directions, either to disapply legislation entirely, so as to remove a duty that exists completely, and for others to modify the existing legislation to reduce the obligation from being a duty, let's say something that the local authority is required to do and which can be directly enforced through judicial review proceedings, like we mentioned, without them being able to say we tried. It's merely something that must be done. And the change that would largely be made to that legislation would be to reduce the obligation from that absolute duty to a duty to use what the Act refers to as reasonable endeavours. And it's that change to the legislation which would fundamentally alter, certainly in the SEN field, the extent of obligations from what has been the law for over 20 years. That is the biggest area of potential change. And as I say, it's important to bear in mind that none of those changes have yet been brought into force. There's no indication as yet when they will be, and the Act requires that if they are to be brought into force, it must only be on the basis that the Secretary of State considers it is necessary to do so in order to combat coronavirus, and it needs to include within any notice a statement as to why it is necessary. But if and when those changes are brought in, they would obviously need to be analysed and looked at. But the fundamental question in terms of the position going forward is likely to be what is meant by a duty to use reasonable endeavours. which is something that Robin has been looking into more closely. And I think
well, Chris, thank you. I mean, it's interesting because one of the questions I'm looking on the screen, and can I also apologise to some of our audience, because apparently we've reached the quota on Zoom, and we've just it's been so much an audience today that we've gone beyond the Zoom limit. But I've now posted it live on Facebook at the same time, and I can see that there's a substantial audience there also, so forgive us for that. But Chris, just one of the questions that came in this afternoon, which I think is quite important, is that Tony asked that the coronavirus, he says, is not yet affecting the education healthcare plan legislation and, of course, the statementing legislation in Wales. And in any case, he says, it seems that some local authorities are refusing to start any needs assessments based on this act. And this does not appear to be lawful, he says. And so perhaps you might want to say something about that before we pass on to Robin.
Sure. Well, that's certainly correct in the sense that the Act sets out at the moment what changes can be made within the legislation to the current duties, and that doesn't include any ability to change the duty to carry out statutory assessments for education, health and care plans or for statements. And so it would not, as it stands anyway, be lawful for any local authority to say that the Act gives them the power to refuse to carry out assessments or to not comply with the deadline to make a decision about that if a request is made, which you may know is 6 weeks from the date a request is made. And so even a notice that, even if notices are given to implement parts of the Act, that's not going to be able, as it stands, to change the duty to carry out those assessments. And one of the things the Act does do is allow the Secretary of State to add to the list of things that can be amended. So there would need to be a slightly longer process gone through to allow that sort of change to be made, or obviously fresh legislation. But the point of the Coronavirus Act is to avoid the need for these changes to be made by legislation directly in relation to the changes it authorises.
Thank you very much. Thank you very much, Chris. I mean, obviously, one of the things that is most valuable to children with special educational needs is, of course, their education healthcare plans and, of course, their statements of special educational needs. And one of the benefits of that, of course, as we all know, is that the local authority must comply with it. There's a duty to comply with it. And I'd like to introduce Robin Jacobs, who's going to talk about really the ramifications of the Act and the introduction of the reasonable endeavour duty. Robin, good afternoon.
Thank you, Mike. Yes, I completely agree with what you say. The great thing about an EHC plan is the local authority has to do what's in the plan. No ifs, no buts, they have to do it. And if they don't do it, you can take them to court and a judge will make them do it. So it's no surprise that people are very worried by the possibility, the power, which this piece of legislation is giving to the government to replace that kind of sacrosanct absolute duty with a duty just to use reasonable endeavours. It is important to emphasise that at the moment it's business as usual, at least technically. The reasonable endeavours duty, that hasn't been brought in yet. It's still the absolute duty under section 42. Quite how you square that with the fact that a lot of schools are now closed, and that the government's brought out guidance saying that even children with EHC plans don't have an automatic right to attend school at the moment, and that it's subject to a risk assessment. I don't know how they square the two things, and I think some of my colleagues are going to address that in a moment. But I just wanted to say something about this term reasonable endeavours. So supposing that at some point the government does replace this absolute duty with the reasonable endeavours, well, what's that going to mean? And the answer is there is no straightforward answer, because reasonable endeavours is not defined in the Act itself. So I started trawling through some case law to try to find out if reasonable endeavours was defined anywhere else. It turns out that the context in which it comes up a lot is actually in commercial contract law. So sometimes contracts will make provision for a party not necessarily to do something come what may, but just to try to do something. These duties that they're called Endeavours Obligations, and there are 3 of them. Reasonable endeavours is actually the least onerous, and without going into lots of very dry commercial law, the crux of it is that the party who's under the duty, they're not required to subvert their own interests or do anything which goes against their interests, and essentially they're just required to identify a course of action and follow that course of action, and if it doesn't work, then tough. So not particularly encouraging if the courts and the authorities choose to adopt that definition. There are some other possibilities, though, that they can turn to for inspiration. Certainly the term reasonable brings up an immediate sort of parallel with the duty to make reasonable adjustments, a duty that some of you will be familiar with. So that requires the responsible body to have a look at what it is they're trying to achieve and think about different things like, well, how much will it cost? What effect will it have on other children? Is it safe for our staff to do? So that's one possibility. And then, of course, there's the public law concept of reasonableness, which will give a public authority a wide discretion as to what they do. And you can only normally interfere if it's a course of action or a decision that no reasonable body would have taken. But in terms of what this means for you, look, even if the duty is downgraded so it becomes reasonable endeavours, clearly the local authority are still required to do something. It doesn't give them carte blanche to do whatever they want or to do nothing. And I think what we're seeing from the courts at the moment, particularly in response to some of what the police have been doing, is that, you know, whilst judges are sympathetic to the pressures that public bodies are under, they're also very keen to maintain the rule of law, and they recognise that this is a period in time where there is potential for abuse of powers. So I think parents would get some sympathy if it turned out that a local authority just wasn't bothering because of the current situation.
Robin, just a question that's coming in live on Facebook. Someone's asked about the duty and the reasonable endeavour duty, whether or not that extends to schools, and if so, in a practical sense, how would a school evidence that?
Well, 2 questions there. Does it extend to schools? The duty to implement a statement rests with a local authority. The buck stops with them. So in a technical sense, if the school isn't implementing the statement, or the plan, as I still call it, or the plan or the statement, as I still call it, then it's actually the local authority's fault. Schools have always been under a slightly different duty. It's a duty in section 66 of the 2014 Act, and that's to use best endeavours to meet the special educational needs of a child. So I think if you feel that a school is not doing what it's meant to, the first port of call is probably still the local authority, because ultimately they're the ones who are responsible. What do you think, Mike?
Well, obviously the school has the duty to use its best endeavours, whether or not there's an education healthcare plan or a statement in existence anyway.
That's right.
And of course, the duty also is upon the local authority to ensure that the school is able to have the resources to be able to exercise that duty. So I suppose in a practical sense, that duties will really, in my opinion, those duties will remain intact through this crisis, I guess, although obviously the schools are closed at the moment.
Well, yeah, which is a big caveat. I mean, if I were a parent at the moment, I would be contacting the local authority and saying, look, we've heard that this absolute duty, it might be replaced by a duty just to use reasonable endeavours. Can you clarify what that means? You know, if this new duty kicks in, what will my child get? What will they stop getting? And I think the starting point should be that everything in the statement should be delivered still, or in the plan, and anything which they say they can't deliver, you know, ask them to justify it. And you know, if they can provide satisfactory reasons, you know, that's might be acceptable. If they can't, then I think you're entitled to probe them on it. You know, potentially to going to the point of judicial review. I think you have to think about the individual pieces of provision. You know, some things are going to be more feasible than others. So, you know, if it's something that requires a child to be at school, that could be harder. If it is therapy, well, think about, can a therapist still visit the home perhaps? Can therapy be delivered using technology like we are now? That kind of thing. Also, I mean, it's possible that you might see additional needs arising from the current situation. So if children are stuck at home, if they can't socialise, things like that, you might start to see additional needs arising. So don't be afraid to approach the local authority and say, well, look, these new problems have emerged. What are you going to do about it?
Yeah, I mean, there's questions coming in, I mean, faster, I think, than what we'll probably be able to answer. But Ken Upton wrote a question. Has there been any indication as to when the Secretary of State is likely to issue the notice temporarily removing or relaxing the local authorities' duties?
Not to my knowledge, Ken. I think a lot of us were scouring the internet, the DFE Facebook page, LinkedIn, government websites, for any indication, because we expected that people would want to know. I couldn't find anything. I'm not aware of anyone else having found anything. Anyone?
No, I think we all have the same.
Everyone's shaking their heads there, so that's probably a fair answer. Robin, thank you very much this afternoon, for that was
my pleasure, Mark.
Very insightful. Well, I think now we're going to be looking at some of the guidance documents, because not only have we got the Act, we've got the regulations, and we've got a number of different documents that have been issued by the government in regards to various things, such as how one addresses the need for vulnerable children, isolation, and of course, isolation in residential schools, that is, and of course, the general duties for safeguarding. And before I suppose I introduce you to Chris Mcfarland, I just thought I'll throw another question in, because there's so many. One of the questions here has come in: how will this affect post-16 education in Wales? So perhaps, Chris, you might, I'm not sure whether you can see that question. The question is, my child, the person says, is part way through a statutory assessment with currently no provision in place for next September, unable to attend school and currently only receiving 5 hours of education otherwise than at school, via a tutor, which they have said will probably finish this summer. They're very worried about what happens next, and that their child will be left with no provision. So perhaps keep that in mind when you start talking about the guidance. Chris, good afternoon, and over to you.
Good afternoon, Mike. Good afternoon, everyone. So thank you all for joining us here today. I hope that you can hear me loud and clear. So my task here today is to talk a bit about the COVID-19 guidance on vulnerable children and young people issued by the Department for Education. Now, of course, I've seen in the Q&A some of our questions apply to Wales, and I myself am a Welshman here in a surprisingly sunny Wales this afternoon. So, of course, that applies to me as much as you. And I'm very sad to say that the Welsh Government have not issued guidance specifically on vulnerable children. There are a series of guidance documents published on the Welsh Government website about coronavirus, predominantly about safety measures to be implemented at schools in relation to the spread of the virus. Naturally important, but sadly I can't tell you how the Welsh Government will approach statements in the same way that I can today about the Department of Education's approach to EHC plans. What I would echo, though, is what Robin said, is where there is no notice and where there is no guidance, it is very much business as usual. So if you're in the process of getting a statement, if you currently have a statement and need support, get in contact with your social workers, get in contact with your local authorities, get in contact with your schools and colleges and find out how they can support. Now, moving on to the Department for Education's guidance, I will be followed in this talk by my lovely colleague Shiroi Zak, who'll talk about school closures and social distancing in residential schools, obviously valid and useful to many of you, and of course Rachel Rees-Carlton, who will also be dealing with the safeguarding issues. Sticking to the vulnerable children guidance, however, first we need to understand, well, who are vulnerable children? And paragraph 1 of the guidance says that those who would automatically fall within this category are essentially those who are under 25 with an education healthcare plan, those with a social worker, to include those with child protection plans or who are looked after by the local authority, but not exclusively those children. So if you have a social worker or your child has a social worker, you should qualify. And of course, those who would meet the definition of what's called a child in need under Section 17 of the Children Act. Truthfully, most of those children, if not all, will have a social worker. So those are those who would fall automatically within the category. Now, of course, there will be others that can and should fall within that category, and I will come on to those later, those without an EHCP. But for those with, essentially, the guidance states, well, how should we support those children? So really, the key question to be asked is, firstly, should those children stay in school? Or secondly, can those children have their needs safely met at home? And of course, safety is a theme running through this guidance. We're all here at home delivering this seminar. I imagine almost all of you are at home listening to the seminar because of the risk the virus presents to us. Now, of course, for those with disabilities and perhaps underlying conditions, that risk may be higher. I know a number of my clients are in social isolation, have their children in social isolation for 12 weeks in accordance with guidance. So, of course, the guidance here reflects that as well, because it's obvious that for those who can't attend school because it's unsafe, can't have therapists in the house because it's unsafe, what do we do with those children? And of course, what do we do with other children? Well, children who, of course, are vulnerable to the coronavirus, but perhaps their needs are so profound, they are so severe that their needs cannot safely be met within the home. What about those with social, emotional, and mental health needs that, of course, might pose a risk themselves or others if their needs aren't met? Again, this is
Chris Jasmine has raised a question. How does the COVID-19 law and the guidance affect children who need to access medical care?
It doesn't comment specifically about medical care in this guidance. It is more about obviously education. So I'm afraid I can't answer that within the confines of this guidance. But obviously, if she'd like to pose a question to us through our website and email address, education@sinclairslaw.co.uk, and give us more specific details, then of course we may be able to provide you with more specific assistance there. But turning back to the guidance, I
guess, Chris, just to answer the question, I suspect there's no, or maybe any members of the panel might be able to answer this, but I don't think there's any quest within the Act to alter Section 100 of the Children and Families Act, which is the duty to ensure a good healthcare plan for children who are at school. If anyone doesn't, maybe nobody knows the answer to that, might be worth looking at, but I don't think that there's any changes made to Section 100 of the Act.
Okay, so thank you, Mike. That's really helpful. So going back then to obviously where we go to the guidance. So paragraph 21 to 30 is where we talk specifically about children with EHCPs. And really the question is risk assessment. So getting that individual child risk assessed by their school and college with consultation of the local authority and the parent to decide, well, how can their needs be safely met? Balancing the risk to their health for attending a school or having a therapist in versus obviously the risk of not having their needs met. And really they'll fall into two categories. Obviously those pupils who can have their needs met at home, either electronically, with therapists in the home, or of course, those who need to go to school, those whose needs are so profound that they must go to school. The guidance does stress that support and for EHCP should be pragmatic. So it should be something that's achievable, something that actually can work, and obviously something that, as far as possible, meets the child's needs. It doesn't give a one-size-fits-all approach, and that is so vital because, of course, you know, our children and young people, they are unique. Although their needs may be similar to others, they are never the same. And of course, it's always important that it's a specific decision made. So make sure that risk assessment is conducted as soon as possible. I will say at paragraph 22, when we talk about assessments, when we talk about reviews, when we talk about amendments to EHC plans, which I know a lot of you are worried about, I myself had to issue 3 pre-action letters to local authorities this week about these very time limits. Well, currently, there is no change. So the regulations are still in effect. The weekly deadlines are still in effect. So make sure those are stuck to, because the paragraph does say that they are proposing changing these timescales in light of the current situation. Now, I must say they haven't set out what they're going to change them to yet. We will keep you up to date. So do keep following us on Facebook and on our website to make sure you keep up to date with those developments. But of course, they do say within the guidance that it will specifically apply to those cases affected by COVID-19. Now, if that holds, it might not be a general change to the timescales, but might actually be specifically to those who may not be able to undertake assessments because they are ill, who perhaps cannot have an assessment undertaken because they're too vulnerable to have that type of exposure. So again, watch this space, but very much we'll try and make sure those are limited as little as possible. And finally, talking about those without an EHCP, or of course those who may be going through that process, they don't currently fall within the vulnerable children parameters automatically, as they don't have an EHCP. Of course, if they do fall into either a child with a social worker or a child in need, they would. But for those who aren't vulnerable children, a risk assessment can still be conducted at the discretion of the school or college. So again, my top tip is get in touch with them as soon as possible. Do bear in mind that although normally this will be the end of term for schools and colleges, we are dealing with a situation where, so do contact them this afternoon, do contact them on Monday morning. If they are not available, the social worker, get in contact with the department. And as I say, with those timescales for EHC assessments or statements and statutory assessments and EHC plan finalisation, you know, make sure you're on top of the local authority, get in touch, get that finalised as soon as possible so you can secure as much provision as you can in these difficult times. Thank you.
Chris, thank you very much indeed, and that was very informative. I'm sorry about some of the internet issues that I think you may have had there. We've had a number of questions that have been coming through, I mean, which we will try and deal with as many as we can. I mean, some of them are absolutely extraordinary, to be honest with you, but I think what I might do is suggest that we will continue with the presentation, and then once we get to the end of the presentation, we will then try and go through as many of the questions as we possibly can. But I know that Shiroi, who's up next, talking about isolation in residential schools, and he'll also be talking about the impact that this is all having on GCSEs and A-levels this year. So, and we have got a number of questions already being put through for that. I mean, for example, Michaela says that will the special education needs students who are due to sit their GCSEs this year have their grades reflected based on the extra time and support they would have had in an exam, such as readers, scribe, extra time and laptops? And another question is that again, in relation to the GCSEs, my son has SEN, but also suffered teenage migraines and anxiety, and has missed a lot of school in recent 6 months and did not complete his coursework for his electronics GCSE. Will he be considered for exceptional circumstances when deciding his grade? Right, well, we'll be, if Shiroi can't answer that question, then the panel will be able to answer it, I'm sure. But Shiroi, please, over to you, and very good afternoon to you. Please tell us about the guidance in relation to isolation and examinations.
Of course, thanks Mike, and thanks Chris. And with regard to Michaela's questions, the second segment of my presentation does in fact deal with that, but I'll provide a bespoke response to both of those questions when I get to that segment. Apologies if there's any overlap with what you've already heard from Chris, but following on from that, I'm here to provide you with a relatively swift overview of the impact of COVID-19 on residential educational settings and temporary school closures, with a particular focus on the impact on examination results, as Mike says. And I imagine that's something that's on the minds of parents, carers, and students alike. Both items of guidance can be found online with relative ease, but I'd be more than happy to circulate a link within the chat section of this Zoom webinar if that would be of assistance. And please feel free to continue to use the Q&A function, and we'll do our best to get to them towards the end of the session. So beginning with residential educational settings, it would be useful to begin with which settings that guidance covers. The guidance is intended to cover mainstream boarding schools, residential special schools and colleges, children's homes, university halls of residence, and other further education providers with residential accommodation. So as you can see, it impacts a large number of students, many of whom will have special educational needs and disabilities that are still to be catered for. And all of the above are essentially considered to be households within the guidance, and the entire setting will need to self-isolate if a resident shows symptoms. Now, although this may sound impractical, it may well be worth ascertaining whether your child's residential setting is in fact enforcing this adequately for their own well-being, if not for the well-being of others. And whether or not a child returns home for that period of self-isolation is a matter for the manager of that residential care setting as per the guidance, along with the parents and or the carers of that particular child. The guidance does, however, state that there needs to be an individualized risk assessment, which sort of overlaps with what Chris Mcfarland was saying about getting onto the relevant authorities to ensure that individualized risk assessment is conducted if you think it's of relevance. That being said, what's classed as a setting very much depends upon the residential layout. It seems as though the guidance here encourages the use of a common sense approach, i.e. if those within a particular flat within university halls, for example, are displaying symptoms, perhaps just that flat can self-isolate as opposed to the entire building. But it does state that individuals within such settings should only return home if displaying symptoms if they're able to do so without using public transport. So bear that in mind. It also does touch on staff ratios. Staff ratios must, not if, not may, but must be maintained at a safe level to protect children and young people. Now, what's meant by a safe level isn't specified within the guidance, and presumably that's decided on a case-by-case basis. It's particularly of relevance with regard to settings where it may well be safer for a child or a group of children to remain within the setting that they're currently in than return home. Using the example of circumstances within a particular child's home not being safe at that point in time. The residential setting must be aware of that, and as such must adequately staff the setting to ensure that individuals in that position can remain there. And for children in special in special residential schools and children's homes that are situated outside of their home local authority, there is to be a collaborative approach between that home local authority and the local authority within which the school is located. Both local authorities do need to liaise with each other. And I think there may well be a lack of communication between the two, which I'll go on to deal with below. A part of this guidance that's a lot more pertinent for a lot of you who will have tuned in concerns the continuity of health and therapy needs for those with the HCPs. In the event that therapy or health support is provided at the residential educational setting, that provision is to continue if a student returns home. The educational setting is responsible for notifying the local authority that the student is returning home to make sure that there is continuity. And I can't help but think that parents and carers are going to have to be proactive in that regard to make sure that that line of communication is kept up. For those with the HCPs, the local authority is to maintain a register of all pupils who have been sent home from their residential educational setting and contact the family frequently in order to ascertain whether additional support is required and how that will be delivered. So do keep an eye out from that. For individuals with no alternative place of residence, it may well affect more students than we think, i.e. international students, care leavers and so forth. Now the institution, despite the fact that a residential contract may be coming to an end given the time of year that this is impacting everyone, that institution needs to liaise with local authorities and individual letting agents to provide the student with alternative accommodation. So in conclusion, with regard to residential educational settings, there seems to be a large degree of discretion left for the particular institution, but we need to ensure that these individualized risk assessments are taking place, and that can only happen if we're proactive in that, because I can imagine the local authorities and institutions may not be doing that with as much diligence as required. But moving on to the part of my presentation which seems to have attracted a lot more questions, the temporary school closures guidance with a particular focus on exams. And Michaela, this is where I'll touch on your questions as well towards the end of this. As you can imagine, that guidance does concern a lot of areas, but I've chosen to focus on exams given, as I say, the particular time of year that this has occurred and the manner in which it could affect the trajectory of a child's life. Now, as you may well be aware, GCSEs, AS and A-levels have been cancelled. and there is no prospect of these exams being reinstated in 2020 as per the guidance. Now, the exact procedure through which the grades are to be calculated remains to be seen, but what we do know is that it won't simply be based on predicted grades, particularly because a lot of evidence suggests that students from socioeconomically disadvantaged backgrounds are likely to have their grades under-predicted in any event. Now, Ofqual, the independent qualifications regulator, is said to be developing, Michaela, this may go towards your question. They're said to be developing a fair and robust process that takes into account a broad range of evidence, including teacher assessment and prior attainment. Now, even though there isn't any explicit reference to students with special educational needs, I think the reality is if this fair and robust process doesn't include special educational needs, that'd be a surprise to me. And if it didn't, I'm sure there would be a challenge to that particular process on the grounds of well, when is reasonableness, or whether it's lawful at all not to take that into account. There's been a fair amount of speculation as to what it may take into account, but the process could, in theory, take into account past attainment levels, mock examination results, performance in class, attendance, a range of factors that students would not have necessarily anticipated would matter at the time. And there are a fair few obvious problems with that. Using a couple of examples, I mean, what if you had a particular teacher who simply did not like you, and it's that teacher that basically has autonomy with regard to what grade you are to receive? There's a real problem there. And what if, much like myself, going back a few years, if you didn't really take your mocks as seriously as you ought to have, and you saved your hard revision and work for the exam that you thought mattered at the time? Now, the goalposts have moved after this match has started, and on that basis, I think it's reasonable to expect a fair few appeals on a micro level, but also perhaps strategic litigation with regard to the process itself, the overarching process itself. If, for example, Ofqual haven't consulted relevant bodies and organisations prior to introducing this process, if there is something unlawful or irrational about the process itself, I think it could be targeted on behalf of clients or concerned parties with standing. And that's something that I'm particularly interested in exploring. Now, Michaela, going on to whether your son will be considered for exceptional circumstances when deciding his grade, I would advise that even though schools are closed, if you haven't already, please do put in your exceptional circumstances forms and evidence, particularly with regard to the coursework that wasn't completed, so that no one can say that you didn't put that in at the earliest possible opportunity. And then we have to wait and see what Ofqual say with regard to their processes as to how the grade will be determined and take it from there. But as a first port of call, I'd make sure that you're abiding by the exceptional circumstances procedure at that school at this point in time. Now, it'll be interesting to see how relevant bodies are coping with the appeals that they may need to decide upon, because I imagine there might be a lot more this academic year than there are usually for obvious reasons. But as I say, at this stage, it's pure speculation on my part. In the event that there is this larger bit of strategic litigation that I speak about, it may well be that individual subjective appeals on behalf of students might need to be stayed and put on hold, pending judicial determination of whether Ofqual's process is in fact lawful. And if a student isn't happy with a particular grade, what has been said in the guidance is that they will be able to sit an exam as soon as reasonably possible once their school reopens or in 2021. An obvious issue here is that, of course, acceptance to universities and deadlines associated with that, people may well be losing out on not only an academic year, but an entire year of their life as a result through circumstances that were beyond their control. Well, I hope that was of some use. In the event that there are further bespoke questions, I'll do my best to answer them. But if not, I sincerely hope you have a wonderful weekend, and please do remember to stay at home and stay safe. Thank you.
Thank you very much, Roy. The sun is really beating here in Cardiff, and I know, is it still warm and sunny in London?
It's quite nice. It is quite nice. Yeah, it's not as nice as it was last week, but I'm not going outside that much anyway, Mike, so it's not too much.
Right. It's beaming through the window here. Well, thank you very much indeed, Troy. And over to Rachel, who will talk a little bit about the safeguarding guidance. So, Rachel, very good afternoon to you.
Good afternoon, everyone. Hope you can hear me okay. I'm speaking from sunny Talbot. It is quite sunny here, but again, I'm not going outside either to keep safe. So the reason I'm going to chat to you just quite briefly, we've had some basic guidance from the government, which was issued on the 27th of March by the Department of Education on the safeguarding of children and young people. The statutory guidance is just for during the current healthcare crisis in schools. So they've said this will apply to all schools, whether it's maintained, non-maintained, independent, academies, trusts, maintained nursery schools, pupil referral units, as well as colleges. And this guidance is just interim guidance, and they let us know that it will be updated as the situation progresses. So, as Chris has already explained to you, the pupils that are able to attend school and the limited amount of people who are allowed to access the school at the moment are the key workers' children, as well as vulnerable children, and they will include those with a social worker and children up to age 25 with the education healthcare plan. And they remain the responsibility of the local authority to remain effective safeguarding and child protection during this period. It seems that each local authority has different rules on what they require or class as being required. Some local authorities have been saying if one of your parents is a key worker but the other one isn't, then you can find your own childcare, and there's been differing between local authorities on that point. Moving towards the Easter holidays, there has been talk that most schools now, there may be a reduction in need, and the local authorities are closing down some schools and moving towards collaborative hubs. They've called these clusters or cluster hubs, and advice is going to also then going to be expanded on this point as the situation progresses in the next few months. What I understand from teachers is that each school will possibly remain in separate classrooms within the hub itself, so that the children have the support of the teachers they know and the guidance from the teachers they know and the children they know, so that they will have the support and try and keep normality within the childcare school setting, where they are being looked after hopefully this would promote then a safer environment, presumably because they are being kept separate from the other classes. That might obviously, by the need, the number of staff available might decrease as infections possibly go up. There might be other needs to change in its weather and how local authorities can adhere to this, but that's the plan at the outset, that these hubs will be kept separate, but we'll have more evidence and information on the cluster information going forward. The guidance on the vulnerable children, that remains, the children will remain a priority to the local authorities, and those the social worker and those up to age 25 with the educational healthcare plan, they are designated safeguard lead, should be either available on site by video or online. And this policy is not a business as usual teaching approach, but this should be in the best interest of the children, should still come first. Any concerns of the staff should be acted on immediately. And there might be the possibility that volunteers are going to start coming through to help teachers, and these volunteers still need to be health and DBS checked to be able to enter the school buildings. And there has to be protection online for possible working remotely and education online. And there's going to be more guidance on that and education proceeding remotely as well. The child protection policy within each school needs to be revised with an addendum COVID policy, and that's got to include, in cases that we are interested in, the local authority regards with the children with vulnerable or educational healthcare plans. So if the hub continues and the children have to move into different teaching locations, the educational health and welfare plan needs to be available at that location prior to the children's arrival, or when they arrive at the latest. They have, sorry, just checking.
Rachel, as you're doing that,
they're going to have access to.
Rachel, as you're doing that, one of the questions that's come in this afternoon is from Hugh Davis. He says, does the safeguarding guidance that Rachel is referring to apply to Wales?
At the moment online it just says it applies to England from what I've been reading. I would say that it needs to be looked at that we are following it at present, but at the moment I can't see that it's been specifically put to Wales. Continuing with what I was following up to is the teachers are also going to have to look at the mental health needs of the children going forward, because that may require extra input during the difficult period, and the expectations of the teachers and behaviours and emotional states of the vulnerable children in their care. But if there's anything else I can answer on those points, I'm happy to do so.
Thank you very much, Rachel. I'm sorry you've had a little bit of problems there with your internet. I think we got most of it. I think that's pretty clear. Well, I mean, one of the big practical problems that we are facing in light of the Coronavirus Act and, of course, the restrictions that the government have introduced is how does this impact on local authority time limits, on whether they will be complying with those time limits and what impact it will have in a practical sense in tribunals when experts will not so easily be able to come along to visit a child at school. They won't be able to see the child at school, won't be able to necessarily even see the child at home. And to what extent will that really have an impact on the way that the tribunal has to then grasp these points and try and resolve the dispute? Charlotte Hadfield with us from 3 Paper Buildings. Charlotte, you're going to be talking this afternoon about the restrictions and the practical ramifications of this. Charlotte, a very good afternoon. I hope the weather's lovely for you there.
It's very nice here, actually. Unusually for Cambridgeshire, it's beautiful.
Lovely.
And I'm not out in it either. So, I'm going to talk a bit about the practical difficulties that the current coronavirus crisis, and particularly the regulations that recently came out restricting movement, are having on how to prepare for tribunal hearings and how tribunal hearings are proceeding. So firstly, by way of a very quick reminder, the regulations that I'm talking about are the Health Protection Coronavirus Restrictions England Regulations 2020 and the Health Protection Coronavirus Restrictions Wales Regulations 2020. They are slightly different in their wording because of the different bodies between the jurisdictions, but the effect of them is pretty much the same, and the restrictions are the same on citizens across both nations. So talking firstly about the background to it, these were enacted on the 26th of March 2020, so that's when they came into force. Slightly controversially, they were not put before Parliament for approval before they were enacted, which is something that's getting constitutional lawyers very excited, but that's sort of outside the remit of this discussion, because the practical effect is that they are now in force. They broadly permit for the closure of premises and businesses, as we probably know. They restrict movements, they restrict gatherings of people in different households, and they create certain offences if certain parts of the regulations are breached. So what does this mean for the general public? Well, broadly, what Regulation 6 says is that no person may leave the place that they are living in without a reasonable excuse. And it goes on to say that reasonable excuses include a number of specific excuses set out in the regulations. Now, the interesting thing, obviously, about saying reasonable excuses include these things is that that suggests that these excuses are not exhaustive. So in other words, in principle, there could be a reasonable excuse that isn't specifically referred to in Regulation 6. Although we have probably all heard various examples over the last few days of different police forces applying these restrictions differently, different police forces misunderstanding the regulations, and in one case I think somebody was convicted of an offence where there is now some concern about whether that was the right offence to convict them of. So pragmatically, there might be difficulties with persuading individual people enforcing these regulations that a reasonable excuse that isn't set out in the regulations is still a reasonable excuse. But my reading of the law is that it's not an exhaustive list. So broadly, the reasonable excuses are you can leave your house to obtain basic necessities for your own household or for a vulnerable person. You can take exercise either alone or with other members of their household. The regulations do not say that you're not allowed to drive to do that. They don't say that you are not allowed to drive more than a certain distance or anything along those lines. Again, we have seen some police forces interpreting these regulations slightly differently, but my understanding is that whilst the government is advising people not to go very far from their house, that is not as yet a legal requirement. Seeking medical assistance, which is really important in the context of preparing for tribunals, attending a funeral, moving house, and caring for vulnerable people. So, turning to the issues that we are identifying in the tribunal, the first thing is that the first tier tribunal was actually quite proactive so far as sendist appeals were concerned, and it decided at a very early stage that it was going to try and continue to hear cases, to hear appeals against the content of EHC plans, to hear disability discrimination claims and so on by video link. And in fact, over the last 2 or 3 weeks, all of us have experienced video link hearings, as well as some telephone hearings. And actually, the initial feedback is it's going pretty well. So the first tier tribunal is getting to grips with the video tech. The tech seems to be working well. Reviews of all users seem to be positive, although I'll be interested to hear what my colleagues in this panel have to say, because obviously different experiences may vary. Because other tribunals aren't sitting, the first tier tribunal currently has a decent number of judges. I'm sure that lots of people who are listening to this will have had the experience of being told that their hearing can't go ahead because there's a lack of judicial resources or a lack of tribunal time. That actually seems to have happened a lot less since the coronavirus restrictions came into force. The difficulties, I think, that are being suffered is that the tribunal is suffering from staff and administrative shortages because people are self-isolating, because obviously different people may be coming down with symptoms that may or may not be COVID-19, but in those circumstances they can't work. And there have also been, I think, some difficulties with things like arranging paper bundles, which not everybody is able to do from home. So how is that affecting preparation for tribunal hearings? Well, firstly, there are potentially general witness issues, because notwithstanding the fact that you can do these hearings from your home, some people obviously will be having to work from home and also at the same time deal with increased childcare obligations, because most of us are not key workers, and many of us who technically could be key workers have taken the decision not to send our children into their normal setting. So lots of people, I think, are in reality having to juggle a full-time job with full-time childcare, and I'm sure I speak for everybody here when I say that it's not always desperately easy. So that could affect the way that people can attend these hearings. The nice thing about a video link is that people can click in and click out very easily. So I would hope that in practice, for example, local authority officers who may need to give evidence, expert witnesses who may need to give evidence, are able to come in for their bit and then go. So hopefully there's that additional flexibility there. The tribunal has said that it will be sympathetic to domestic interruptions, and as somebody with a 2-year-old who does relatively frequently pound on my door and scream my name, it's good to know that the tribunal is not going to be horrified if that happens. So overall, quite a lot of flexibility to deal with what are likely to be inevitable witness issues because of the current prevailing situation. The interesting question is what's happening with expert assessments as we prepare for trial. The question really is, firstly, does attending an expert consultation count as a reasonable excuse under the regulations? Well, the first point is the one that I've made already, which is that the categories of reasonable excuse under the Act aren't exhaustive, and so there is some leeway for a reasonable excuse that doesn't appear under the regulations. Sorry, I think I said Act, I mean regulations. So the first point is there could be a reasonable excuse that is not specifically set out in the regulations. The most obvious reasonable excuse in the regulations that might apply would be travelling for the purpose of obtaining medical assistance, and there is some additional information about that in Schedule 2 of the regulations, which says that medical assistance includes, so again not exhaustive, but will include accessing dental services, opticians, audiology services, chiropody, chiropractors, osteopaths, and other medical or health services, including services relating to mental health. So that could, in principle, include NHS services like occupational therapy and speech and language therapy. There is possibly a question mark over whether it would include reports by, for example, a specialist ASD teacher, or a specialist teacher for the visually impaired, or a specialist teacher for the deaf. So there are some that explicit reasonable excuse will definitely cover some of the experts that we see in principle. But then the second question is, if I'm getting an assessment for the purposes of a tribunal, does that count as medical assistance, given that the assessment is probably not going to involve therapy, in the sense of it's not going to be a speech and language therapy session or something along those lines? Now, here, there's space for argument, because on the one hand, you might say, well, it's not essential, and it is an assessment for the purpose of gathering evidence, so it's not really medical assistance. On the other hand, you might say, well, hang on a minute, this is an assessment that is going to be used in evidence, yes, but it's also going to form the basis of the provision, the therapeutic provision, that this child or young person needs, that needs to be specified in the plan. So I think the short answer is, it's not clear whether travelling for those assessments is going to be accepted as a reasonable excuse under the regulations. There is some risk that it won't be, but there are arguments that it could be. And at the moment, we don't really have any case law or any clear indication from the government in terms of guidance about that. But certainly the inclusion of things like audiology services suggests that it would be. The second question is, pragmatically on the ground, my understanding is that an awful lot of the experts who usually carry out these assessments are self-isolating or suddenly find themselves with childcare responsibilities, which in practice limits the extent to which people can travel to them, or they can travel to people anyway. Now, what seems to be happening, and again, I'll be really interested to hear what my friends at Sinclairslaw have experienced with this. Certainly, as far as I can see, speech and language therapists and occupational therapists are saying that they can assess remotely. That's something that can be done. I have seen that some specialist teachers, so for example, a specialist teacher of autism who I heard from recently, was saying that she didn't think that she could do an assessment other than face-to-face, because at the moment her professional regulator requires her to certify that the assessment took place in a face-to-face private context. So it may well depend on what individual therapists see as their obligations, whether they think they are obliged to see that child face-to-face or not. I don't know whether educational psychologists have agreed to assess remotely or not, and perhaps that's something that that Mike, you and your colleagues can address. But certainly, at least some experts are saying yes, we can do assessments, we can do them remotely. That's not a problem. So that, I think, is the broad picture at the moment in relation to expert evidence, because obviously availability of expert witnesses and their evidence is absolutely key to a successful tribunal hearing.
Charlotte, Charlotte, one thing that just springs to mind is that, and one of the questions this afternoon was that for parents, some of whom will have had their assessments completed before the lockdown, and local authorities might not, or vice versa, the quality of that report that is going to be laid before the tribunal is likely, isn't it, to be seen by the tribunal to be the one that, the better quality is the one that has done the proper assessment. So that's going to have a practical impact on special needs tribunal hearings, surely.
It might do. I suppose it's difficult to say in a way, because the quality of reports obviously varies between experts anyway, and you often find that a local authority expert has taken a different approach to the approach that the parental expert has taken. I suppose in a sense only time will tell whether in fact, are you talking about a situation where the parental expert has been able to see the child or young person face to face, but then the local authority expert is in a situation where they have to do it remotely?
Well, yeah, I mean, you'd have a child that will have been assessed by the psychologist in the school setting, seeing the child in situ, whereas if you're late in getting your assessment to counter that, whether it's the local authority or whether it's the parent, you're not going to have that full four-dimensional report, really, are you, in the same way?
That's true. That's true. An awful lot. I suppose in practice, it may be that some children will have been identified as being on the edges of vulnerable and therefore might have got a place in a setting. Although obviously, even if the local authority expert is lucky enough to assess that child in the educational setting, they're not going to be seeing that child in their normal setting in most cases, because either the child will be at a completely different school because of the hub arrangements that we've heard about, or they'll be in the same school but the curriculum is going to be significantly different and the provision is going to be significantly different. So so there's that. But yes, I think you're also right that if we're talking about children who are at home because they don't have a school place and the local authority expert is having to assess them at home, then yes, I think any expert probably would agree that they are disadvantaged in terms of assessing special educational provision if they can't see that child in the setting. I think that's absolutely right. Yeah. And
yeah,
I guess
sorry to interrupt you.
No, not at all. So I think I was going to go on and just talk about the arrangements for video hearings, because in terms of the basic nuts and bolts of it, the tribunal will set up the video hearing, and 2 days beforehand, the tribunal will send everybody the link to the hearing. So that's the basic tech. You have your link, you click on it, and you can join your hearing and participate. What we've been thinking about in 3PB is what you might need alongside that. So, for example, if I'm representing a client in a video hearing, I want to have the same ability to talk to and communicate to my client as I would in a live hearing. Now, in a live hearing, what that would normally mean is that the client sitting next to me, I normally have a stack of sticky notes that I hand to the client because I expect that a lot of helpful information will be coming across from the client whilst I'm doing the hearing. And so as I'm doing the hearing, I like to see a little pile of sticky notes building up that will just inform me on the bits of evidence that come out that perhaps nobody realised were going to be given, but the parents know something about. How do you replicate that when you're doing a video hearing? Well, my suggestion would be that you set up some outside channel with a client that you have maybe on a different screen or on your phone or at the side in some way, something like maybe Google Hangouts or Skype or perhaps WhatsApp, and that provides a medium where the client can just put in their thoughts on the evidence as the evidence is coming in. So I think that's really important, because otherwise it's a difficult situation, I think, for any parent or young person to be sitting there thinking, well, this is my hearing, but I can't really talk to my barrister and I can't really, you know, get across what I want to say. The other thing that I think would be really useful is if you contact the opposition prior to the hearing, it's also useful to have an alternative channel set up with them, because what often happens in these hearings is that in a live hearing, the judge might say to me, can you go and have a chat with your opponent and see if you can find some common ground on this section? Or your opponent might want to talk to you because they want to concede something or something along those lines. And so how do you replicate that? Well, my feeling is that you have a separate chat facility set up by agreement with the other side that acts a little bit like the corridor you go into. So I think it's a really good idea to think about all the different avenues of communication that you'll need before the hearing starts, and then just set them up, because the tribunal won't do all of those things for you at the moment. They'll only do this is the hearing, dial into the hearing. Now, in terms of timescales, at the moment, I don't think that the government has formally amended the timetables for producing an EHC, for doing an EHC needs assessment or producing an EHC needs plan. I see Chris Mcfarland nodding, and that is good enough for me. So I think that at the moment they haven't done that. They have intimated, sorry, that's a really barristerial word. They've said, they have said in previous guidance that they are going to look at extending those timescales, but I think they're probably going to want to wait and see how everything pans out at the moment, because I think that there is an awareness that they don't want to be meddling too significantly with processes that are already in chain or setting up a kind of two-tier process. So that hasn't happened yet. In practice, there is probably going to be some slippage on deadlines. I know that some parents are experiencing that already. I think that there is going to be a little more, I mean, that was the case even before this happened, let's face it. It was it wasn't exactly uncommon for a plan to be issued outside the normal statutory timescales. And I think there's probably going to be more sympathy to that at the moment, both from the tribunal. And I think because of that, when we're dealing with the other side, probably both sides to an extent, we all have to be sensitive to the prevailing situation. So perhaps where previously we might have waited till the very day when something was due and then said, where is it? At the moment, we might want to be saying, is this something I need to jump on immediately? Which it might be if you've got a really acute case, or you've got a child, a young person who's really in need of help and can't really wait another day. Or are you going to say to yourself, I'll give them a couple of days leeway and then I'll chase? So just to sort of emphasise to the other side and to the tribunal that you're dealing with all of this reasonably and you're aware of the overarching situation. But in terms of securing EHC needs assessments and so on, the timetables for that haven't changed, as I think as I think others have said. And there's no, so if tribunals are writing to people and saying the tribunal hearing can't take place because of this, because of the coronavirus, for example, that's absolutely not the case. And I'm happy to answer any further questions that anyone has on how tribunals are working.
Charlotte, thank you very much. I mean, that is really quite a large amount of the questions have been over, you know, the time limits and in what way will it affect an order being made by the tribunal? Will they still be bound by the same rules and the time limits? Whether they still, will they issue plans? Some parents have written in to say that their local authorities have said there's going to be no more plans and that we're going to suspend it until May, and we're going to wait a lot longer until this crisis is over before we really go back into the statutory regime. I mean, really, that is not a lawful approach, is it?
No, there is nothing in place at the moment that allows them to do that. If the government decides to extend the timescales, it will have to do it by statutory instrument, because it can't do it by guidance. And there is no guidance at the moment from the government saying it's okay for there to be slippage in the timescales. The only parts of the Children and Families Act that we think are likely to be affected at the moment are annual reviews, sending a child to the school named in Section I, so Section 43, and reasonable endeavours, which we've already talked about. Now, the fact that the duty to send a child to their institution of choice, for example, is suspended doesn't mean, in my opinion, that you can't have a first-tier tribunal hearing right now and say, I want this school named in Section I. So the local authority doesn't have to send the child to that school, and if that school is currently closed, then obviously there's an impossibility issue there as well. But in my view, what's happening, the changes that are anticipated at the moment are not going to result in a situation where the local authority can say, we're not naming that school in Section I. They can only say, if the government gives out the requisite notice, we're not going to send that child to that school at the moment.
Thank you very much, Charlotte. And another question, really, these are general questions coming in. I mean, Sadia, for example, asks, and there's a lot of concern in relation to not only the impact on education, but also the impact on social care, because, you know, a lot of people are reliant on support at this time, particularly at this time. I mean, one of the concerns that I've spoke about on Facebook, for example, is that parents who are having a terrible time managing their children or child, some of whom might be violent, aggressive, difficult to manage, and requiring, whilst they're at school, 2-to-1 care, and now they're isolated in a small, relatively small place in their home, unable to go out, and the dangers that presents in itself. There's a lot of concern about that. And what Sadia says is, I mean, she says that her son's carer is no longer able to take him out due to self-isolation. Can she request direct payments to spend on him for sensory support and PE activities, etc.? And can her local authority refuse? And if they refuse, can she appeal that decision? And another question she asked at the end is, would legal aid be available to her in those circumstances? So I'll leave that open to the panel. I mean, I know the answer, but I'm sure that the panel, people want to hear all this from me. So anyone want to answer that question for Sadia?
I can start answering it and see if somebody wants to finish. I think it depends what's defined in their care plan and what the need is really in the care plan for what they, whether it is for stimulation, or it's, it can be looked at and expanded, because, we are in exceptional times, and that if there isn't the availability to go outside with support and no new supporters are available, speak to the social worker first, obviously, then see if that could be an option and get some things delivered, but obviously see what the social worker says to see if you can work around, and emergency sanction having some sort of extension on your care plan. Is that right? If anyone wants to add?
Yeah, I would agree with that.
One of the shocking questions that have come in this afternoon, Chantal has written in, and she says that she's extremely concerned about her 22-year-old physically healthy child with a learning disability. She says that last night, due to the COVID-19 situation, she was told that her daughter her child, I should say, will not be treated if she becomes symptomatic of COVID-19, and has been told that she will not be resuscitated. The consultant states that she would be too difficult to manage in an acute setting and too risky to manage for extubation. She has behavioural problems due to global brain damage, and she's extremely worried about that. I mean, what an extraordinary thing to say to Chantel. Anyone want to have any thoughts on that? No?
Well, the immediate thing that springs to mind for me is that if she's under section at the moment, they've got certain duties towards her, which include safeguarding her welfare, and a DNR doesn't, in these circumstances, doesn't necessarily feel like it would be consistent with that. I think, I mean, if she lacks capacity, isn't the right thing to do to have an MDT assessment and a best interests meeting? But I mean, it just seems like it's a pretty shocking thing to hear. If that's what's happened, it's a pretty shocking thing to hear.
It seems like it's just a across the board kind of decision that's being made there. I mean, whether or not it's just, this is just the opinion of one doctor, or whether they're speaking on behalf of the trust, I don't know. I suspect they're not speaking on behalf of the trust, because that decision seems extraordinary in my view, and most certainly is capable of challenge.
I think you could definitely launch something in the Court of Protection in asking for a guardianship possibly, or deputyship, about the health of her daughter, and then apply, because you want to make the final decision and it shouldn't come down to them.
And another question comes in from Kathy. She says that her daughter is autistic and needs vestibular movement, and for the last 2 years they've had to take her out for a drive every single evening. And she's extremely worried about the restrictions. She's worried that even the CAM psychiatrist said that she needs to go out for a drive for her mental health. Can she still do it in light of the restrictions? I mean, Charlotte, we were looking at that earlier in the non-exhaustive list that applies to the reasonable excuse point.
Mm-hmm. Well, I would say, firstly, there's nothing, as I said before, there's nothing in the regulations that prohibits you from going out for a drive. Exercise is not defined. I mean, I suppose, to be fair, I doubt most people would hear exercise and think going in a car, but then we have to look at this in a holistic way and think about the needs that our client base has, and the likely forms that exercise might take for them. So we know that this kind of therapy has incredibly soothing, calming, beneficial effects for people who have sensory regulation issues. I can't see anything in the regulations that prohibits it. I can't see, I suppose one could say, well, I'll go shopping and I'll take a slightly longer route in order that I'm ticking 2 boxes, because I'm getting basic necessities, and at the same time as getting basic necessities, I'm giving my daughter this therapy that she needs. If one's feeling cautious or anxious about the prospect of being stopped. But in principle, if a medical professional has said that this therapy is necessary for this young person, I would have thought that at least arguably does amount to a reasonable excuse under the Act.
I'm inclined to agree with you. I mean, the question is, who's going to determine what's reasonable? It's a very difficult one.
It really is.
For anyone.
We're at such an early stage in all this. We've got an awful lot of government guidance which doesn't always bear as close a relationship as perhaps it could be to the specific restrictions that are currently in force. And the situation is inevitably going to change. It's likely the legislation will be amended a little bit. It's likely that guidance will be refined. So we can all only really do the best we have with what we've got.
I think as a practical step as well, just going back to that issue of going out in the car, I think if you're having this advised by experts, get them to send you letters and print those letters, because at the very least, if you feel like you have to do it for your child's needs, then at least that supports it being a reasonable excuse. As Charlotte said, it's very unclear what that actually will mean in accordance with the regulations, and more importantly, as you mentioned earlier, is that police officer going to know what the regulations say and its non-exhaustive list? Because what the law is and what it's practically being applied as may be 2 different things, and we're not going to pop down the magistrates and fight a fine at the moment. So do bear that in mind. But taking that evidence with you it has got to be a good practical step if you feel like you have to do it. Obviously, if you can work around it, do work around it. But if you must, then I would certainly advise to do that.
Robin, Helen Harris has asked a question saying that she won at Tribunal in December 2019, but her speech and language therapy and the occupational therapy provision has still not yet been put into place. And should she be pushing the local authority for this?
Well, most definitely. And if they don't agree to it, you're well within your rights to go to the High Court. I mean, one of the interesting things at the moment is that the local government ombudsman, which quite often deals with complaints about failure to implement provision, and which is sometimes argued by the local authority to be an alternative remedy to judicial review, has shut down. They are not accepting any more complaints. They've frozen the complaints that they were dealing with. So you can quite legitimately say to the High Court, well, we're here to enforce this provision by way of judicial review, and the local authority can't accuse us of failing to pursue other remedies because the local government ombudsman is shut. Best practice to make a complaint first. As always, do it in writing, keep a record of it. But yes, as things stand, it's not reasonable endeavours because that hasn't been implemented. They have to do what it says in the plan. And yeah, if they're not, then they're on the wrong side of the law.
And Shiroi, I suppose these people in these situations can still nevertheless apply for legal aid, can't they? To enforce the terms of their statement and the education healthcare plan, because as Robin said, the reasonable endeavours duty hasn't yet taken over, and that's still applicable. Chris, one question that's been asked this is Chris Barnett. One question has been asked by Karen Crimmins. She says that she's worried about the annual review and in what way will this crisis impact upon the duty to comply with the annual review deadlines, which was obviously have to do each year. So, Chris, have you got any thoughts on that?
Yeah, I think the answer to that is that annual reviews are one of the potential areas within the Children and Families Act and in the Welsh legislation as well that could be modified or indeed disapplied, so that the obligation to undertake annual reviews would not be in place for a period of time. And one thing I didn't mention earlier, which is true for all of the notices given to modify the legislation or to disapply it, is that those notices can only last for a period of up to a month at a time. So they would need to be reviewed and reissued if they were going to continue for any length of time on a regular basis. So for an annual review, even if it stops for a month, it may be that then it would need to be resumed, and the timescales would potentially move back slightly, but not necessarily by a huge amount. But I think even if there is a disapplication of that, the position then has to be that the existing EHC plan remains in force and enforceable, either fully or through the reasonable Endeavours obligations, until there is a further review.
Thank you very much, Chris. And Chris Mcfarland, maybe you might be able to answer this one. Concerned by Joanne, she says that what about children who have EHCPs already in place and which are being reviewed and they've gone way past the deadline? Does the current plan remain in force until the new plan is finalised, she says?
Well, yes, that would generally be the case. If you already have a plan and you have a draft plan, then the final plan is what the local authority are obliged to deliver. In terms of current deadlines for amending plans, as I said already this week, I've sent off 3 pre-action letters on different cases about failure to finalise plans within time limits. They still apply. So if you want that plan finalised, you certainly should reach out to the local authority and tell them they are in breach of the time limits. Obviously, through us would be best, as pre-action letters normally get that done. But of course, if you want to stick with the old plan, then of course, I think you don't need to chase them right now. They've got plenty on their plates. Just give them a break.
Shiroi, another question that's come in from Gabrielle. She says her local authority is saying that online Zoom learning with our children poses a safeguarding risk and therefore is not to be allowed. She asked what the panel thinks about that.
I'd certainly ask them to particularise what they mean by that, especially because there are a number of educational institutions that are in fact employing online learning, and from what I hear in certain circumstances, quite successfully. What you tend to get when you push back in situations of this nature is either an unsatisfactory response that's amenable to challenge, or they will cave. And I'd put them to proof in that regard. And with regard to questions, Mike, sorry, I know you're the host, but if we have time, there has been a question from Mandy that I wouldn't mind answering, if that's all right.
Please go ahead. Please go ahead.
Well, this question from Mandy says that her 17-year-old is autistic and dyslexic, has a statement and is in a specialist resource base, who's recently struggled with A-levels since September. An assessment carried out privately as the school couldn't afford an educational psychologist appointment for some time, showed his needs are different now from when he received his statement age 10, and explains a lot of his struggles. And Mandy's concern is that the school estimates his AS grades, but that estimate's being based on what work he's done this year, whilst his needs have not adequately been met. What options do you have? Now, Mandy, as I said earlier, it's slightly unclear as to exactly what Ofqual are going to say, but what has been said so far is that there will be some sort of appeals procedure if you disagree with the grade that's been imposed. And if that appeals procedure is something that you don't necessarily want to pursue, you will have the opportunity to resit those exams. But of concern here is the fact that it seems as though your son's autism and dyslexia were in fact known to the educational institution and the local authority, but you had to carry that assessment out privately because the school didn't offer the appointment for some time. And what I would say is that in a situation where you have declared a disability from the outset, the onus isn't on you or your son to demonstrate the severity of that disability. That ought to have been done by the institution itself, and reasonable adjustments should have been made. So I'd put the school on notice of that right now to avoid any complications down the line, and make it quite clear that they may well have known towards the start of the academic year, had they complied with their duties under the Equality Act. And that's certainly something that if you'd like to take that up further, I'm sure the people at this firm will be able to assist with regard to that. But I hope that answers your question, Mandy.
Thank you very much, Roy. Chris Barnett, one of the questions that have been asked also by Tracy, she says that how will this current crisis have an impact on children who are at home currently, out of school, without really any alternative provision? Will they be able to get education remotely? I think she's referring, of course, to the Section 19 of the Education Act responsibility. So what's your thoughts on that, Chris?
Well, Section 19 is mentioned a couple of times in the Act, and obviously, again, none of that has yet been implemented. But it is included in the provisions which could become subject to a reasonable endeavours obligation. So currently, local authorities are required to make provision for any child who's out of school for due to exclusion or for medical or indeed any other reason. But that duty could well be reduced to a reasonable endeavours duty as well. And it's also mentioned in the context of school closures that if a school closure direction is given, again, none of them have been, then Section 19 is disapplied in relation to any children who are out of school as a result of those closure notices. So they haven't used that process yet, so it doesn't apply yet. But it could well be, if formal notices to close all schools were given, then that could mean Section 19 is fully disapplied around the country. So it's a little up in the air in terms of how that will work, depending on what notices are given and when. The law remains at the moment that Section 19 is in place, and so if someone is not in receipt of any education at all, then the local authority should still be taking steps to ensure that a child is receiving appropriate education, whether that's by being placed on the roll of a school and accessing whatever is being offered by that school, either remotely or otherwise. And if they are obviously a vulnerable child or entitled to be in school, then to be able to attend potentially as well. But I think with that sort of situation, whether it applied prior to the current situation or has been caused by it, then it would make a lot of sense for the parents to be contacting the local authority directly and pushing them to make provision. And if nothing still happens, then it may well be that, again, a sort of reaction letter from a solicitor would be the way to compel the local authority to take action, or at least to explain, if it has reached the stage of reasonable endeavours, what reasonable endeavours they've made consider whether that's open to challenge as well.
And I guess that's really the answering not only that question, but also from Bev, who says that her 8-year-old grandson has only just settled back into mainstream school and has been refusing to go there before Christmas with severe anxiety. And they've just got him settled back, and now he's isolating at home. And what support could be expected from the school? And I think that you probably covered that, Chris.
Yeah, I mean, obviously it depends whether he's got an EHC plan as well, but even if not, then the duty to put provision in place for someone who's out of school is currently there, and it's something to very much take up with the local authority if nothing is happening to find out what it is they propose to do and how they propose to put something in place. What that will be and how it will work for a child, obviously with particular issues. It may not be as straightforward as for others, but that doesn't affect the duty directly at this stage. And so again, contacting the local authority, and if they do nothing, then potentially seeking legal advice would be the way to go.
Well, thank you very much, Chris. Just running through these questions. Tracy says that her daughter's, prior to the lockdown, was doing a 2-week trial at a private school, and the local authority agreed to fund that school, and the school has accepted her, but no paperwork or amendments to her statement have yet been issued. And she asked, where does she stand on that? Robin, have you got any thoughts on that? Robin, sorry, could you hear me? Did you have any thoughts on Tracy's question? If not, Robin, maybe Chris, if you can hear me. Chris Mcfarland. No?
Yes, I can hear you, Mike. Apologies for that. So sorry, can you just repeat the question for me? I think our internet cut out a little bit there.
That's okay, I understand. We're all relying on our internet here.
I can hear you now.
There we go, lovely.
There we are.
Tracy says that her daughter, prior to lockdown, was doing 2 weeks a trial at a private school. The local authority agreed to fund that school and has accepted her, but no paperwork or amendments have yet been made to the statement. And she asked, where does she stand when it's time to return to school?
Well, I think you'd have to take the view that nothing has changed. You'd expect the offer to be honoured. If the local authority wants to retract it, they'd have to explain why things are different now.
Yeah, thank you, Robin. Just still going through these questions, and there's some of them are quite long. Can you clarify? One person says, the local authority is still responsible for physiotherapy, occupational therapy, and speech and language therapy, although direct therapy may not be practical due to isolation. Can I insist on having that done via Zoom or Skype, and that resources are sent home? Charlotte, have you got any thoughts on that?
Sorry, I've just realised I was still muted. Well, at the moment, the local authority still has a duty to provide that. So the answer is absolutely yes, you can. I suppose very technically you could say to the local authority, if it is direct therapy from a therapist that's specified in the report, in the plan, sorry, at the moment you could say, I want my direct therapy as my plan says. I think most people are being a bit more pragmatic about it, and also I suspect a lot of people who have their children and young people at home don't really want a succession of experts coming in and out of the house because of infection risk. But yes, absolutely, you can ask the local authority to provide that, and you can remind them that they have a duty to provide it under Section 42, because at the moment that duty has not been suspended or modified.
Thank you very much, Charlotte. That also answers some of the questions that have been raised on Facebook. I'm busy here looking at the questions on Facebook. We've had over 146 of those. But I think we broadly covered that. Richard asked that same question regarding direct speech therapy and occupational therapy in the EHCP, and whether that could be dealt with remotely. I mean, what do you think about the sort of quality of remote access to therapy in terms of speech therapy and occupational therapy? I know that Melinda Erickson wrote a message and she's a well-known expert, asking for guidance really that should be issued to experts who are dealing with the tribunal. We touched upon that earlier, but you know, to what extent can that be really quality therapy?
It's genuinely really difficult for me to judge, because I don't think it's anything that's really been tried on a sort of wide scale. I don't think that I have yet had a case where the assessment has been done remotely. And the only, prior to the coronavirus restrictions being introduced, the only circumstances in which I can think of that might have been done would have been as an adjustment for a child who or a young person who for some reason couldn't manage a face-to-face assessment, which is possible. So I think it's genuinely really difficult for me to say, partly I suppose because I'm not, although I read a lot of expert reports, I do have to keep reminding myself that that doesn't make me an educational psychologist or a speech and language therapist. So it's difficult for me to say. I'd be really interested to hear, I suppose it's a bit early in the day to know, but I'd be really interested to hear from experts who have been carrying out remote assessments. Can I ask if any of your colleagues at Sinclair's have had any remote assessments done yet? No. We're in uncharted waters here, really, aren't we?
I have a couple scheduled in the next couple of weeks, but nothing quite yet. So watch this space, I suppose.
Well, I think we will just sort of wrap it up shortly, but the one question I think is certainly coming through loud and clear in relation to social care. There's a real concern in relation to what social care departments might do in this situation regarding the relaxation of the duties. Chris, that's Chris Barnett. Have you got any sort of advice that you might give parents who are really worried from social care perspective about being left high and dry in these kinds of situations?
I mean, it's going to be very much dependent on what notices are given by the Secretary of State and what other changes may be brought in over time. And it's very difficult at this stage to speak about concrete challenges and situations that are going to arise. In the longer term, if provision isn't being continued or is indeed being reduced or changed, then obviously the underlying social care duties are slightly different to education as well. So it will require a careful thought, I think, to be given as to how that's going to be challenged, both in terms of individual cases, if provision is reduced or is not being delivered, or if care plans are amended as a result of the current situation. And again, Roy mentioned about strategic litigation in one context, but if local authorities are taking general and blanket views as to what they're going to do, or indeed just generally reducing or removing provision, then that may be something that's more open to a wider sort of challenge, which could be, once the position becomes clear, if the local authorities are doing that, could then potentially be taken forward.
Thank you very much, Chris. Well, yes, I mean, really, we've covered quite a lot, and I've done my best to ask to the panel most of the questions. And interestingly, as we were talking, one person responded on Facebook saying that in answer to Charlotte's question about whether or not therapy has been conducted successfully via electronic means, Zoom, Lisbeth says, we've had an excellent experience with speech and language therapists providing therapy on Zoom. So that's good news. So
that's absolutely fantastic.
We're making some good progress here today. So listen, well, thank you all to you so very much. As to all of my guests, to Chris Mcfarland, to Robin Jacobs, Chris Barnett, Roy, Rachel, and of course the wonderful Charlotte, our dear friend from 3 Paper Building in London. And we will always support you, Charlotte. You know, you've been a real warrior for us, winning so many.
Lovely.
And we hope to win a heck of a lot more. Well, thank you to you all for tuning in. We are quite overwhelmed by the number of visitors we've had and people watching. I know that we've had over 300 views on Facebook already, and we've reached the quota on Zoom. I mean, a good opportunity for us to think, well, during this crisis, we can do some more of these, and we can have some questions and answer sessions. And please feel free to come up with some topics and drop me a line on Facebook. I always love to hear from you. I know I always talk about different issues, and I'm so pleased and proud that you follow me, and I really enjoy doing what I do. It's been a wonderful career for me, and I hope I can carry on doing it for many, many years yet. So thank you all very much in these very, very distressing times, and it's particularly difficult when it's sunny outside and we all want to go out, but we can't. Stay at home, keep safe, and thank you all so very, very much for watching. But don't forget, ask any questions, send out your questions over to Sinclairslaw and education@sinclairslaw.co.uk. Thank you all so very much.